Currently, I am going to be discussing the non-public consultation process, and this webinar is designed for both public and non-public administrators. I want to make sure that as we go through this first phase of non-public consultations between January and March, that we have the ability to understand what our responsibilities are and what should be discussed at this time. First of all, I think it's important to discuss the responsibilities of the parties to the consultation agreement. So the administrators that are sitting down talking about consultation, there are some responsibilities that each party should have some knowledge on. And first of all, each party should know the legal requirements of the consultation process. They should know the legal requirements of each title program that they plan to participate in. They need to know the allowable services provided by the equitable share of each title program. Each participant should attend all Department of Education sponsored trainings dealing with equitable services, and they need to keep the focus of the consultation process on the specific needs of the eligible students and make decisions about services provided in a collaborative manner. Now, there are some general rules about the consultation process and equitable services. Those general rules that are extremely important, I just listed a few of them out here because this is where we tend to have the most difficulty with people not following some of the guidance and rules that need to be followed when we're dealing with equitable services. The first one is districts cannot pay the non-public school directly for anything. So the district cannot pay the non-public school directly. Number two, districts cannot pay for non-public school staff to provide the equitable services to their buildings. Three, the district has the authority to decide the method by which equitable services will be provided. Number four, if the district is providing a service meeting the specific needs of the eligible non-public students, those equitable services must be provided by the district unless it's impractical. And five, the provision of equitable services begins on the first day of the school year. Now, what I want to do right now as part of the consultation process is talk about the timely and meaningful consultation. What does this mean? Now, the goal is to reach agreement between the AEA or public school official and the appropriate private school official. That reaching of agreement is grounded in a timely, meaningful, and open communication between the parties on key issues relevant to the equitable participation of those students, teachers, or other educational staff and family members in the non-public school. It's also important to realize that successful consultation begins well before the implementation of services. It establishes a positive, productive working relationship, and it makes planning effective, continues throughout the implementation of equitable services, and serves to ensure the services provided meet the needs of eligible students and teachers. Now, as part of this, when we're talking about meaningful consultation, consultation between an LEA and a private school officials must include early discussions to prepare for the next school year so that there is a timely start to the Title I or title programs, okay, to those title programs. To be timely and meaningful, consultation must occur during the design and development of such agencies' programs before the LEA makes any decision that affects the opportunity for eligible private school children teachers, and families to participate. And another one, consultation must also be ongoing throughout the school year to help ensure effective implementation, service delivery, and assessment of equitable services. So when we're talking about the consultation process, in the consolidated application in CASA, there is a process where we document certain information. So we're going to document whether or not a non-public school will be participating in a certain title program. In addition to that, what services will be provided and some other questions that we're going to answer. That is the written aspect of the consultation process. But the consultation process continues all year long. So even though we filled out the information in the consolidated application area, that does not mean that the consultation stops. If the needs change halfway through the year, you don't have to go back in and resubmit everything in the consolidated application in CASA, but you will need to come to some agreement between the public school and the non-public school as to what changes need to be made on what was decided. And it probably should be documented somewhere so that if an issue comes up later on, you will have proof either as the public administrator or the non-public administrator of what you actually ended up agreeing to. So remember, the consultation process is ongoing. It's throughout the school year. It's before the school year starts. And so that's what we have. So now, what does timely and meaningful consultation mean? It means that, first of all, the district must consult with appropriate private school officials during the design and development of the agency's title programs. Consultation must occur before the district makes any decisions that affect the opportunities of eligible private school children to participate in those title programs. The representative parties to the consultation agreement should possess the authority to act on behalf of the school district, AEA, or private school. They should possess the goal of reaching agreement on how to provide equitable and effective programs for eligible private school children. There must be ample time and a genuine opportunity for all parties to express their views, to have their views seriously considered, and to discuss viable options for ensuring equitable participation of eligible private school students, teachers, and other educational personnel and families. It also assumes the district has not made any decisions that will impact the participation of those private school students and teachers in the applicable programs prior to consultation. The district should consult with private school officials about the timeline for consultation and provide adequate notice of such consultation to ensure meaningful consultation and the likelihood those involved will be well prepared with the necessary information and data for decision making. So what that means is we have this, for the first time frame, which I'm going to talk about a little bit later, is January 15th to March 15th. If a school district wants to hold a consultation meeting with a non-public school, you should give them a reasonable amount of time to get the information together. Don't call them and say, hey, I want to have a consultation tomorrow. That's not reasonable. That's not ample time for them to be prepared. So please make sure that right now you're getting the information that you need so that you can do the first part of the consultation process between January 15th and March 15th. Timely and meaningful consultation. Well, publication of a specific dollar amount of services a non-public school has available in a particular title program, even though we do not have that specific dollar amount of what the equitable service amount is, consultation does not stop. We can continue to do this and move forward with the consultation process. I'm going to give some suggestions later on about what you should do in that situation, but consultation should still keep happening even though you don't know what the specific dollar amount of equitable services will be for the next year. Also, the parties to the agreement should focus on the specific needs of the non-public students and teachers and how those services can be provided. After the students' needs are identified, the services can be ranked based on priority. And to assist the parties, the previous year's non-public equitable share amount can be used as a guide to establish an amount available in the consultation process. And after the dollar amount for the non-public services is published by the department, the parties can revisit the identified needs of the non-public students and teachers to clarify what services can be provided based on the prioritization of needs and the amount of funds available for those services. Now, this is a typical process that you will go through when you're answering the questions as part of the consolidated application in CASA that will allow you to complete the non-public consultation agreement. The department would recommend the following steps. The non-public school needs to review their student data pertinent to each title program to identify the specific needs of their students and teachers and whoever else, depending on what title program you're talking about. The public school or AEA should contact the non-public school to arrange a time and place for the consultation. If after a reasonable amount of time, since we know that the first part of the consultation process happens between January 15th and March 15th, if the public school has not contacted a non-public school by now, then I would recommend that the non-public school contact the public school to see when that consultation process can be set up. Also, at the beginning of the consultation process, the non-public school provides the specific needs identified through their review of student data, and those needs should be prioritized by the non-public school based on their importance. The public school and AEA informs a non-public school of the title program services it plans to offer students, teachers, and families during the next year that may address the needs of the non-public school students, teachers, and families. If there are specific needs of the non-public student, teachers, and families not addressed through the suggested offerings of the public school or AEA, a discussion needs to occur to determine how those needs will be addressed through services by another entity or third-party contractor. And after title program allocations are published by the department, the public school or AEA contacts the non-public school to finalize the services to be provided based on the amount of funds available for services. Now, most of you received information about timeline as part of the consultation process within the consolidated application in CASA. Now, this is the first part that we were talking about. So between January 15th and March 15th, district representatives will reach out to non-public administrators within their district boundary to discuss what, if any, services under title programs the non-public school would like to participate in during the upcoming school year, so the 2021 school year. All submission requirements related to the process can be found at this link. In addition, the public school district is responsible for submitting the non-public consultation agreements to the department. So after the meeting is held or during the meeting, the public school district will complete the non-public consultation agreements that will be submitted to the department through the consolidated application. If anybody wants to know what the questions are as part of the agreement, they can end up clicking on this link here, and it will take you to those questions. The non-public school should be well prepared with the necessary information and data to make decisions about program participation. So the student needs assessment for each program, each title program should be available as part of the consultation process so decisions can be made. And the non-public head administrator will receive an email when the district submits the non-public consultation agreement to the department. So, as I said, the public school will end up completing the non-public consultation agreement within the consolidated application. They will then submit that to the department. When it is submitted to the department, the non-public head administrator will receive an email saying that the non-public consultation was submitted, and the email will instruct the administrator, the non-public administrator, to log into the CASA system to access the non-public confirmation of consultation agreement. At this point in the process, it is imperative for the non-public to verify which title programs their buildings will receive services under. Once the non-public administrator confirms this within the consolidated application of CASA, changes cannot be made to participation. So, to give you an example, if I were a non-public school and I had the consultation with my public school, and I said, we will participate in Title I and Title II, but we will not participate in Title IV. And then the public school enters that information into the consolidated application and then submits it to the department. I will then receive an email that says, I will be participating in Title I, in Title II, and not in Title IV. If that's what we agreed to, then I need to confirm that that was what we agreed to, but understand after I confirm it, it will not allow you to change participation after the non-public confirms. Now, we have another part here of the consultation process. Now, the first part happened between January 15th and March 15th. It was pretty much to decide who would be participating and what title programs you would be participating in. That was the main crux of everything. But between September 1st and October 1st, the description of services for non-public consultation agreement will be finalized in the consolidated application of CASA. Again, remember, consultation does not stop just because it's October 1st and we fill this out in the process. Consultation is a process that happens throughout the year. It's just that by October 1st, no more changes will be made within the system in the non-public consultation agreement in the consolidated app. Okay, so the consolidated application for federal title programs funding will open for public school districts on September 1st. At that time, the amount available in equitable services will be seen on the non-public consultation agreement. The district needs to reach out to the non-public school again during this period to finalize the description of services that will be provided under each title program. The district and non-public school will also discuss whether or not funds can or should be transferred for use from one title program to activities to another title program. Now, as part of this process, Title II and Title IV can be transferred to certain other programs. So part of the consultation process between September 1st and October 1st, there will be a discussion of whether or not Title II or Title IV funds will be transferred to another fund to be used based upon that title program. Now, please understand, if the district does not transfer funds, then the non-public cannot transfer funds. So if the district doesn't transfer funds, the non-public can. If the district transfers from Title II to Title I, the non-public has the ability to transfer their share of Title II dollars to Title I, but only Title I. So in other words, the non-public share can be transferred only if the public school decides to transfer, and only to the fund, only between the funds that the public school is transferring to. Now, again, it's important. Participation in services under a title program cannot be changed once they were verified in January and March. So in September and October, you cannot change participation, period. The head administrator will again be notified of the non-public, will again be notified when the non-public consultation agreement is submitted to the department by the public school, and both the district and non-public building should have a signed copy of the final agreement in both the public school and the non-public school. So it will happen as it did on March 1st, between January 15th and March 15th. The district will submit the finalized updated consultation agreement to the department. An email will go to the non-public administrator. The non-public administrator will then confirm that that was what was agreed to. And then what should happen at that point in time is a copy should be signed by the public school and the non-public school, and a copy with both signatures should be in the files within the non-public school as well as the public school. Now, what I'm going to talk about is I'm going to talk about third-party contractor services next. So, as part of the consultation process, a third-party contractor may be hired to provide equitable services to eligible non-public students on behalf of the district. The process to request those third-party contractor services are as follows. First, during the consultation process between January 15th and March 15th, the non-public school should request to receive equitable services through a third-party contractor if that is their wish. So if the non-public would like to receive services from a third-party contractor during that first part of the non-public consultation process, the non-public should tell the public school that they would like to receive third-party contractor services for whatever title. Now, as part of that non-public request, the non-public should identify the specific title programs that they would like to receive those third-party contractor services from. The third part of this step is the district should then inform the non-public school how and when a decision will be made about the delivery of services to eligible individuals. Number 4, the district should thoroughly consider the views of the private school officials on the provision of services through a contract with a potential third-party provider before making a decision. And last but not least, if the district disagrees with the views of the private school officials on the provision of services through a contract, the district must provide in writing to the non-public school officials how the equitable services will be provided, with an analysis of the reasons why it has chosen not to use a contractor. And a typical reason in this case would be the district has the ability to provide the service, they plan to provide the service anyway, and they can provide that service in a more cost-effective manner. So, as part of the third-party contractor, first thing that's going to happen is if the non-public school wants to receive their equitable services for a title program through a third-party contractor, during the first part of the consultation process between January 15th and March 15th, they will request that a third-party contractor be provided. I would recommend that if there is a specific third-party contractor that the non-public believes would be good, they could also recommend that. After that, the district is going to inform the non-public school when they will decide about how those services will be provided. The district should be should thoroughly consider the views of the private school officials before making a decision about the third-party provider. And if the district disagrees and decides to provide those equitable services themselves instead of through a third-party contractor, the district must provide the non-public officials in writing with a reason for not choosing to provide those equitable services through a third-party contractor. Now, what is important here are some other considerations from the aspect of a third-party contractor. After meaningful consultation, an LEA is responsible for planning, designing, and implementing equitable services for private school children and may not delegate that responsibility to the private schools or their officials. Next, the district may provide equitable services directly or indirectly through contracts with individuals and public and private agencies, organizations, and institutions, so long as those entities are independent of the private school in the provision of those services, but the district remains responsible for oversight of that program. And last but not least, the district must make the final decisions with respect to services to provide to eligible private school children. So that is what that is indicating, is the district makes the final decision as to how those services will be provided. Some other things that we identified over this last year was the use of federal funds for the purchasing of food. And so I thought it was important as part of this process to include it in here so that we would understand that before we go into the consultation process, that certain things should not be included as a service within the non-public consultation agreement. So as a general rule, federal grant funds cannot be used to provide food or drinks during professional development activities, gatherings, receptions, networking sessions, or any other type of meeting. That's the general rule. Considerations on use of federal funds for food. When a grantee is hosting a meeting, the grantee should structure the agenda for the meeting so that there is time for participants to purchase their own food, beverages, and snacks. When planning a meeting, grantees may want to consider a location in which participants have easy access to food and beverages. 3, there are extremely rare situations when federal funds could be used to provide food and drinks during professional development activities, gatherings, receptions, networking sessions, or any other type of meeting. While these determinations are made on a case-by-case basis, grantees will have to make a compelling case. The unique circumstances they have identified would justify these costs as reasonable and necessary. And purchasing alcoholic beverages is never allowable and strictly prohibited. Number 6, in planning a conference or meeting and negotiating with vendors for the meeting space and other relevant goods and services, grantees may only pay for allowable costs. If a hotel vendor embeds food and beverage cost into a hotel contract for the meeting space, the grantee should work with the hotel to have the food and beverage cost identified and backed out of the contract, and have the price they are paying for meeting space appropriately adjusted to reflect the fact that food and beverages are not being purchased. And last, the cost of food and drinks cannot be funded with indirect costs generated by the use of federal grant funds because they are easily associated with specific cost objectives and properly treated as a direct cost rather than an indirect cost. So you shouldn't even use the indirect cost portion of using federal funds to purchase food and drinks. Now, considerations on the use of federal funds for food during travel. Okay, now we have, now what we're doing is let's say we live here in Iowa and we are going to a professional development opportunity in Florida. And so what can I claim? Can I use federal funds to purchase food while I'm on that travel for professional development? So understand that travel costs are the expenses for transportation, lodging, subsistence, which means supporting oneself at a minimum level, and related items incurred by employees who are in travel status on official business of the non-federal entity, which would be the non-public school, or if it were a public school, the public school. Such costs may be charged on an actual basis, on a per diem basis in lieu of actual cost incurred, or on a combination of the two. Now, the method of reimbursement used is applied to the entire trip and not to select days of the trip. So if I can't go a daily per diem rate on the first day, but on the second day, I'm going to use actual cost. You have to use the same methodology of reimbursement. So if it's per diem, you got to do it the whole time you're on the trip. Or if it's actual cost basis, then you got to do it the entire time. Next, the charges are consistent with those normally allowed in like circumstances in the district's non-federally funded activities and in accordance with the district's written travel reimbursement policies. So the most important thing to remember here is that when non-public teachers end up traveling, what they are allowed to be reimbursed for is based upon the district's travel reimbursement policies and not what the non-public's travel reimbursement policies are. So they're going to need the non-public staff that are traveling need to make sure that you have an understanding of what is reimbursed based upon the district's travel reimbursement policies and what is not. The use of federal grant funds to provide food or drinks can also be limited by the district's written travel reimbursement policies. If the district only provides 2 meals per day in its written travel policies, the use of federal grant funds will only be limited to 2 meals per day. So understand whatever is in the district's travel reimbursement policy is going to apply to both public staff as well as non-public staff. Now, whether food and drinks are considered subsistence and allowable as an expense under a federal grant is dependent on whether the food or drinks are already provided through other means while traveling. So if you were traveling out of state, like in Florida, and they were providing, let's say, lunch at the meeting, you could not claim for a lunch if lunch was provided as part of the professional development during that time. So you will only be reimbursed for those meals that are within the district's travel reimbursement policy and those meals which aren't already provided from some other means. So if the meals are provided as part of an activity causing the employee to travel, food and drinks may not be funded with the federal grant funds for the meals provided by other means. And no federal grant funds can be used for food or drinks when 3 meals a day are provided as part of the activity. So you get nothing if 3 meals are provided as part of the professional development activity. Cost incurred by employees for travel, including cost of lodging, other subsistence, and incidental expenses, must be considered reasonable and otherwise allowable only to the extent such costs do not exceed charges normally allowed by the district in their regular operations as a result of the district's written travel policy. Now, if these costs are charged directly to the federal award documentation, charged directly to the federal award Documentation must justify that participation of the individual is necessary to the federal award, and the costs are reasonable and consistent with the district's established policies. So this is going to go to some other things here, which we're going to talk about in a minute. That participation of the individual is necessary as part of the federal award. Now, let's say, for instance, that the district does not have a travel reimbursement policy. If they do not have a travel reimbursement policy, then the federal travel reimbursement policy rules apply, which can be found here at 2 CFR 200.474. So if we run into this situation and you don't know what they are, give me a call, and I will try to direct you to the area where you can get the information. Okay, now what is professional development? Professional development means activities that are an integral part of school or LEA strategies for providing educators with the knowledge and skills necessary to enable students to succeed in a well-rounded education and to meet challenging state academic standards, and sustained, not standalone, one-day or short-term workshops. Has to be intensive, collaborative, job-embedded, data-driven, and classroom-focused. So in order to be considered professional development, and therefore reimbursable under title programs, it can't be a sit and get one-time thing. Okay, not a standalone one-day thing. It has to be sustained, intensive, collaborative, job-embedded, data-driven, and classroom-focused. In addition, professional development must be secular, neutral, and non-ideological. It must be based on the student needs assessment and must be supplemental in nature, not supplanting what the private school would otherwise provide or be required to provide under state law. Same thing for public school. So it must be supplemental in nature and not supplanting what the public school is required to do already or required to provide. Now, this is the important part that I was talking about earlier. Who can receive professional development funded with federal funds? The funding eligible school leader means a principal or assistant principal or other individual who is an employee of an elementary or secondary school is an employee of an elementary or secondary school and is responsible for the daily instructional leadership and managerial operations of the elementary or secondary school building. So to give an example, in this situation, if a superintendent would typically not meet this definition of professional development, so we should not use federal funds to pay for the superintendent to go to some meeting. Or in a non-public schools case, you wouldn't want somebody who just oversees, like the superintendent of the diocese would not meet this requirement. It's going to have to be somebody who is an administrator at the building level who is responsible for either daily instructional needs and management of the school building operations. Those are the only people that should be receiving professional development for that. Last but not least, I've also included some helpful links that will get you to some information like the complaint form link. So I didn't talk about that today, but I put it in there anyway. Most of the information that you will ever need on any title program can be found on the ESSA Guidance and Allocations link on our website. The non-public consultation agreement questions are also in here on a link. And the information about the CASA system is also included on this link. So I appreciate everyone very much. And I hope that the information we provided at this point in time gives you a little more understanding as to what you can and cannot do and what the timelines are for completing certain things as part of the non-public consultation process. So thank you very much.